And second, he demanded that the money be paid within 36 hours. What? One might expect more care, wow, from a federal court before it so blithely discards sovereign dignity.
The dissenters, led by Justice Alito, also with Thomas, Gorsuch, and Kavanaugh, which means that Chief Justice Roberts and Justice Barrett did side with the Democrat appointees on the court.
The Supreme Court backstabs America. Thank you very much, Judge Amy Coney Barrett and Judge John Roberts, for not solving anything and for allowing this continuation of takeover of the executive branch by the judiciary to continue. On February 13th, the United States District Court, Judge Amir Ali from Ontario, entered a TRO, okay? And the way these generally go, right, it's a TRO, and that can sit for a little while the status quo is maintained. Then you come and you have a full hearing for a preliminary injunction, and that makes it more permanent. Then from that preliminary injunction, you can appeal this, generally speaking. So he entered the TRO, and that is not generally appealable, stopping the government from enforcing pauses of disbursements of foreign funds. So the government paused the funds. The judge entered a TRO unpausing the funds so these grifting agencies can get paid. The present application does not challenge the government's obligation to follow that order. Now, on February 25th, then the judge came back and ordered the government to issue payments for a portion of the paused disbursements, which were those owed for work already completed before the issuance of the restraining order on February 26. Now, several hours before that deadline, Trump and the government filed this application to vacate the 25th order because the 25th order said you make those payments and requested an immediate administrative stay. So then the Chief Justice entered an administrative stay shortly before the 11:59 deadline. That's when we said John Roberts got woken up out of bed and subsequently referred the application to the court. So this is all just procedural history. Now it gives us some context for what they're going to rule on here, but that application is denied. Okay, so the application to stop the order forcing them to pay by midnight is denied. Now that deadline has now come and passed, so that deadline's expired. So given that the deadline has now passed, there it is, and in light of the ongoing preliminary injunction proceedings, so we're going to have further proceedings on this, the district court, so Judge Amir from Ontario, should clarify what obligations the government must fulfill to ensure compliance with the TRO, with due regard for the feasibility of any compliance timelines. So the order heretofore entered by John Roberts is vacated. So this is pathetic, right? Now, here is what they have responded with in the dissent from Judge Alito writing. Here's the question. Does a single district court judge who likely lacks jurisdiction, like Judge Amir Ali, because remember, this is a contract dispute. These are whiny so-called doctors and advocates, whatever that means, who are saying we are entitled to money. We're entitled to back pay, right? There's a whole separate court that is set up for this. Hopefully they talk about it, but I believe it's called the Court of Federal Claims. We'll come back on that and see if Alito explains it to us, but it's a different arena, okay, where they go, they've got jurisdiction. When you have a dispute with the government, you don't get to sue the government and then just stop the government from doing its job. You can go make a claim for monetary damages, but there's a different court for that. He says, but does Judge Amir Ali, does Judge Amy Berman Jackson, do any of these judges, do they have unchecked power to compel the government of the United States to pay out, and Alito says, and probably lose forever, $2 billion taxpayer dollars? Can they do that, one single judge? Well, the answer to that question should be an emphatic no. But a majority of this court apparently thinks otherwise. Judge Alito says, I am stunned, saying in capsule form, this is what happened here. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department and the U.S. Agency for International Development. This group, this agency, they brought suit and they claimed that the current administration's pause on their foreign assistance payments is unlawful. On February 13th, the district court, says Alito, issued a TRO requiring the government to halt its funding pause. It is based that decision on a finding that the AIDS doctors are likely to win, likely to succeed. They brought a claim. They said that the Trump administration violated the APA, the Administrative Procedures Act. Now, after issuing the TRO, the district judge, Judge Amir Ali from Ontario, grew frustrated with the pace at which the funds were being dispersed. He says, my friends need their money and they need it now. And on February 25th, he issued a second order requiring the government to pay out approximately $2 billion. Now, the judge brushed aside the government's argument that sovereign immunity barred this enforcement order. Trump said, you can't can't sue us here. We're immune here. You can go sue us in a different forum, but not here. And he took 2 steps that, unless corrected, would prevent any higher court from reviewing and even stopping these payments. First, he called this injunction a TRO. He just labeled it a TRO. Okay, and we know all the time how much liberals like to just change labels, even though it doesn't change what is underlying in reality. It's an injunction. It's not a TRO. Okay, we can see it. It's a gigantic injunction, and it's disgusting. And second, he demanded that the money be paid within 36 hours. What? Now, this left the government with little time to even try to obtain review of what it regarded as a lawless order, and that's why he did it. Go fast. Get that money now. And this is the impeachment trap that we've brought up many times here. The judge is trying to ensnare Trump, trying to cause him to violate a court order, and they were pretty close. Now, the district court moved for a stay pending appeal in the district court, but the judge shrugged off the government and their sovereign immunity argument. They ignored the government's representation that the money in question, once it goes out, we're not getting that money back, okay? These so-called AIDS doctors are going to go hog wild with it. The government quickly filed an appeal in the United States Courts of Appeals for the District of Columbia, but with only 4 hours to spare before the deadline, the Court of Appeals dismissed the government's appeal. They said, oh no, it is a TRO. They say it's a TRO. I mean, he identifies as a TRO. It's his lived experience that it is a TRO, but it's not. At face value and determined it lacked appellate jurisdiction. Oh, it's in his email signature. I am a TRO. Says, with nowhere else to turn and the deadline fast approaching, Judge Alito writes, the government asked this court to intervene. And at the last moment, the Chief Justice issued an administrative stay. Thank you, John Roberts. Now, unfortunately, a majority, even John Roberts, has now undone that. And as a result, the government must apparently now pay $2 billion post haste, not because the law requires it, simply because a district judge called Amir ordered it. Now, as the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. And today, the court fails to carry out that responsibility and acquiesces to Judge Amir, saying, time does not allow a lengthy discussion of the legal issues presented by this case, but a brief summary suffices to show that Judge Amir's order should be vacated or at the very least stayed. To start, it is clear that Judge Amir's enforcement order should be construed as an appealable preliminary injunction. It is an injunction. Everybody knows it's an injunction, and everybody can see it just looking at it. Not a mere TRO, okay? A TRO, as its name suggests, is what is called temporary. It's the first word. And its proper role is to restrain, the second word. Challenged conduct for a short period of time while the court considers whether more lasting relief is warranted. Now, the order here, which came from Judge Amir at the district court, which commanded the payment of $2 billion, a vast sum that in all likelihood can never be fully recovered, is in no sense temporary at all. Once that money is out, it's gone. Nor did the order merely restrain the government's challenged actions in order to, quote, preserve the status quo. Judge Alito citing other cases that explain how this works. Rather, it acts now as a mandatory injunction requiring affirmative action by the government. And given its likely irreversibility, the district court's enforcement order effectively gave the AIDS doctors a portion of the ultimate relief that they seek. Meaning, it's like the end of the lawsuit is they want that money. So it's not a temporary restraining order. It's like a judgment of finality at this stage, because you can't undo that. It's not pausing things and holding things in a circling holding pattern. For these reasons, the Court of Appeals did have jurisdiction in Washington, D.C. to consider the government's appeal, and we have jurisdiction to review and the ability to summarily vacate the lower court's erroneous judgment, saying even if the majority, Roberts, Amy Coney Barrett, and the 3 libs, even if they're unwilling to vacate Amir's order, it should at least stay the enforcement order until the government is able to petition here for a writ of cert. And I wonder if this is kind of an instruction to Trump on that in some way. Now, in considering whether to issue such a stay, we ask at minimum 2 questions. 1, whether the moving party is likely to prevail on the merits, and whether that moving party is likely to suffer irreparable harm. So is Trump going to win? And if we don't take action here, are the American people via the Trump administration going to lose? Now, the Judge Alito is writing here in a footnote, to the extent that likelihood of cert is a relevant factor to this decision, it's also met here. We're going to grant this. Recent years have seen a sharp increase in district court orders enjoining important government initiatives, and some of these has been labeled as unappealable TROs, citing the Dellinger case. That's the special counsel who was fired by Trump, that lawsuit, saying clarification of the standards for distinguishing between a TRO and a preliminary injunction is a matter that deserves this court's attention at the present time, right? right? We need that badly to define what this is, how these judges can get away with this. If they're going to issue a TRO, when does that actually become a preliminary injunction that warrants an appeal? The same is true regarding the scope of the APA's waiver of sovereign immunity as well. So he says, in close cases, Alito writes, we also take into account other equitable considerations. Like if you put a bunch of stuff on a scale and balance it out, you consider that. Here, these factors weigh in favor of a stay. Alito writes, the government has shown Trump a likelihood of success on the merits of its argument that sovereign immunity deprived Judge Amir Ali of jurisdiction to enforce its order. Sovereign immunity bars a suit by private parties seeking to impose liability which must be paid from the public funds in the Treasury, right? Otherwise, everybody's going to sue the government to get their money. But that is exactly what the district court ordered here, citing this other case, saying the restrained defendants shall pay all invoices and a letter of credit drawdown request for all contract work completed before February. Now, sovereign immunity may be waived, but to sustain a claim that the government is liable for money damages, the waiver of sovereign immunity must extend unambiguously to those monetary claims. In other words, the waiver, Trump is saying, you can't sue me except for money. If you sue me for money, it's no problem. I waive the right to be sovereign from that. It's a strict requirement. It must be explicit, writes Alito. Trump didn't do that. Attempting to satisfy this strict requirement, they point to the APA. They say, well, the APA says that there is a waiver of sovereign immunity for certain actions. Now, that language, Alito writes, as we have explained, it distinguishes between a specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. But the relief here from these AIDS doctors more closely resembles a compensatory money judgment rather than an order for specific relief that might have been available under equity, saying an injunction to compel the payment of money past due under a contract or specific performance of past due money was not typically available in equity. And so sovereign immunity thus appears to bar the sort of compensatory relief that the district court ordered here. He couldn't have done this, but they try to escape this. So then they point to this other case called Bowen, a 1988 case. Now in that case, the Supreme Court held that the APA's waiver of sovereign immunity, it did cover a district court judgment that reversed a final order from HHS. In that case though, Bowen simply recognized a basic reality of the APA. After a court sets aside that agency action, a natural consequence may be the release of funds to the plaintiff down the road. Now, we've since clarified that that sort of relief has been ordered here, but Judge Amir Ali also failed to mention or even reckon with any of this before he issued his $2 billion order. Judge Amir did not take it into account of our previous suggestion that the proper remedy for an agency's failure to pay, there you go, may be to seek sums and what is past due. There it is in the Court of Federal Claims. We created a whole separate court for you to sue the government in. The most that can be said is that in the district court's denial of Trump's motion for a stay, it cited but did not analyze a handful of cases echoing Bowen and their waiver of sovereign immunity. One might expect more care, wow, from a federal court before it so blithely discards sovereign dignity. Wow, Judge Alito. One might expect more from Judge Amir Ali from a federal court. So finally, Alito writes, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the injuries, right? So you can't overly punish the person's being sued, in this case, the government. Now, in this case, they are. Judge Amir's enforcement order functions as a universal injunction, defying these foundational limits on equitable jurisdiction. The district court, Judge Amir, ordered the government to, quote, pay all invoices and letter of credit on all contracts for pre-TRO work that was completed. That order encompasses more than just the respondents in this case. Okay, there's a certain set of people who are suing here, and he said, you got to pay everybody. And Judge Amir offered no reason why universal relief to non-parties is appropriate here. Like, why should they get, like, they're not suing. Why should they get their money? And this is not the sort of case in which the only universal relief is feasible. Even supposing the APA allows universal vacature of rules in certain circumstances, the district court's order of direct monetary payment bears no resemblance to that. And nobody has suggested that the government is unable to identify respondents allegedly owed funds and pay out only them. Limiting the scope of relief in that matter would be significant. Below, at the lower courts, the government said that they seek $250 million, right? The people in this lawsuit. That's still a large figure, but it's only a fraction of the $2 billion that were ordered. So the people who are suing are owed $250, they claim, but the judge ordered $2 billion to go out. It's ridiculous. An emergency motion Ferguson was referenced for that. Now, the dissent continues. Alito writes, there's also harm to the parties and others. Now, the government has shown that it is likely to suffer irreparable harm. If we have to give out this $2 billion, we're not getting it back. The government is represented. It would probably be unable to recover much of that money after it was paid because it would quickly be spent by the recipients and dispersed out to all the Democrats. $2 billion. Respondents did not credibly dispute this representation. They're like, oh yeah, no, like once it hits our account, it's gone. We're going straight to the trans clubs. And the district court did not find that it is incorrect. So we usually balance equities, okay, when it's in close cases. We weigh the relative harms, says Alito. For the reasons I've explained, this is not such a case here, and our analysis could end there. Now, nevertheless, their equitable arguments are insufficient to justify a denial of a stay. They say that failure to pay them would cause them irreparable harm because without those funds, they couldn't continue to do their work. They might have to reduce the work they do, like holding their little meetings. As a result, they claim recipients of their services would suffer. Now, these consequences, of course, are serious, says Alito, but any harm resulting from the failure to pay amounts that the law requires would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. If we sent this case back to the Court of Appeals, it could still render a prompt decision. If it decided in favor of the respondents, the government would be obligated to pay all the money that is due, and then they would have suffered only a short delay in the receipt of the payments. And if the government prevailed and won on its sovereign immunity argument, which Judge Amir completely neglected, neither the respondents nor any of the recipients would have suffered any unlawful consequences. They just ignored all of it. So in sum, Alito says, the factors we consider in deciding whether to issue a stay weigh strongly in favor of granting that relief, saying, as he wraps up, today, the Supreme Court makes a most unfortunate misstep that rewards an act of judicial hubris to Judge Amir. That is a scolding from the Supreme Court, okay? That's a big thing that's going to go in the history books. It imposes a $2 billion penalty on American taxpayers. And the Democrats are the ones who are launching these lawsuits. These are blue agencies through and through, and they want their money. They're going to steal that money, in my opinion. It's my interpretation of what's happening to the funds, but that money is going to be repurposed into Democratic operations. It's not going for the goodness of America. It's stolen money. Trump came in and cut it off, and they're suing their doctors and civil servants and global health leaders and advocates and blah, blah, blah. You guys lost the election. The American people have spoken. We don't want you to do those things anymore. And they're such civil servants that they're now suing the people that they're supposed to be serving. Thank you guys for doing such a heroic work out there, serving all of us. The district court has made plain its frustration with the government, and respondents raise serious concern about non-payment for completed work. But the relief ordered is quite simply too extreme of a response. A federal court has many tools to address a party's supposed non-feasance. Self-aggrandizement of its jurisdiction is not one of them. I would chart a different path than the court does today, so I must respectfully dissent from Judge Alito, and that is a good dissent. Here is how Fox News was reporting it. Shout out to Carly Bonney for grabbing this clip for us. Here is how they explain it.
A judge's order that could force the Trump administration to resume foreign aid payments. A lot of this has to do with USAID, and Shannon Bream is on that. Shannon, what happened?
Okay, so this is one of the very first things from this term to make it fully to some kind of decision from the U.S. Supreme Court. And this is about foreign aid that was ordered to be paid out by a lower court judge. There were groups who take in USAID money, and they had gone and said, listen, this freeze is harming us. And they went to the district court judge, that lower court level, and he said, yes, the government has to pay this out. It went through the appeals, got to the Supreme Court. They, by a 5-4 vote today, say they won't put that judge's order on hold, but they've told that lower court, now you need to explain to the Trump administration exactly what money you want them to pay out. The dissenters, led by Justice Alito, also with Thomas, Gorsuch, and Kavanaugh, which means that Chief Justice Roberts and Justice Barrett did side with the Democrat appointees on the court. They've said they're dissenting, and let me read you a little bit of this. They say the court makes a most unfortunate misstep that rewards an act of judicial hubris and imposes a $2 billion penalty on American taxpayers. They say the relief that's been ordered to pay this money out is an extreme response. It says a federal court has many tools to address a party's supposed malfeasance. Self-aggrandizement of its jurisdiction is not one of them. In plain English, they think the lower court got it wrong and was way out of bounds to order this money paid out. They say it's going to be to the harm of the American taxpayer. They've now said to that lower court, explain to the Trump administration exactly what they have to do, but the order stands. The money's got to go out.
Shannon, how big of a surprise is this?
Listen, anytime it's a 5-4, you can't be sure exactly. You know, it was a close decision. One vote flips either Roberts or Barrett the other way, and this is a different decision. So we knew they were wrestling with it, and the fact that this lengthy dissent has been written, led by Justice Alito, means the court really struggled with it. But it is a loss for the Trump administration. Of the nearly 100 cases now pending, there's some other stuff we're waiting.
Yeah, and it is a little bit of a surprise, I'd say, in a way, also not in a way, because we're still at the early stage of all of this. A disappointing decision today, and Amy Coney Barrett and Judge Robert once again failed America.